Welcome to today's verdict. I'm your host and trial attorney, David Lesh. We have a great show today. Three very important topics. The first one has to do with home health care pay and making sure that everyone's getting the fair pay to be able to be a home care worker. It's very, very important that we give our support. And we have an interesting guest who's going to be coming on. Second up, we're going to talk about those TikTok videos that are unfortunately causing young people to be harmed in such a way that we feel they may need legal protection. We have an attorney on who's going to be talking about what he's doing to prevent these TikTok videos from ever hurting any of our youth. And finally, last up, we have Madison Square Garden and the use of surveillance software to prevent attorneys from entering the building. I think it's fascinating, especially since I'm an attorney. So stay with us. Today's verdict has so much coming up right now. Welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have with us today Matthew Bergman, who's going to be bringing an action or has brought an action with respect to some TikTok videos. Matthew, first of all, thanks for being here today.
Well, thanks for having me.
You know, I have a 12-year-old son who watches TikTok all the time, and my wife recently was a little upset with some of the videos she's seen. In particular, what she's read about, you know, the blackout challenge. Tell the viewers a little bit about why you're involved with the blackout challenge and what you're seeking to do, if you could.
Well, just kind of by background, I formed the Social Media Victims Law Center about a year ago in response to the mental health crisis our young people are having as a result significantly from social media addiction and abuse. And since that time, I've spoken to literally thousands of parents whose children have been injured or in many cases killed through social media. And one of the most pernicious aspects of social media are these challenges that are on the TikTok platform. And in particular, the blackout challenge, where children are encouraged to choke themselves to get a euphoria when they release the ligature. But tragically, in many cases, children are unsuccessful and accidentally choke themselves to death.
You know, and I know that I've seen, you know, the Benadryl challenge, the milk crate challenge, the skull breaker challenge. I mean, this is a pattern on TikTok. The legal elements of a case like this, what needs to be proven to hold TikTok accountable?
Well, first of all, you have to prove that that this was not an accident or coincidence, that the challenges are part and parcel of the structure of the product, of the platform, and that they are designed to addict children, and they're designed to provide children with content, not that they want to see, but that they can't look away from, for the express purpose of addicting them and keeping them online. Because when you're online, you are not the customer, you're the product. They're selling your eyes on screen, be you a kid or be you an adult. And so that's the first thing that you have to prove. And then you have to prove that the child had saw the challenge online and that it impacted his behavior. And even after TikTok ostensibly took the challenge offline, children still have ready access to it through other means. And so all of these cases are very difficult. The only certainty we have is that these companies are going to, you know, use everything they have to fight us. They have all the money in the world, but, you know, we really believe that we have justice on our side. And we believe that these parents need to be heard and that these products need to be safer.
In the past, have these cases settled? Has TikTok come up and at least offered monies on the milk crate challenge or Benadryl challenge? Have they tried to offer something on these cases, or do these cases usually have to go to court? What's been happening in the past, these challenges?
Well, this is very new litigation. We really are at the cutting edge of a new thing. So we don't have a pattern or practice yet. You know, we understand that in the past, some cases have been resolved, but everything they're telling us is that it's go to trial. And of course, as a trial lawyer, there's nothing I want more than to talk to a jury about why the profits of this company were more important than the life of this child.
Well, it's, you know, you have a very sympathetic clients here. You're talking about children basically, and you're talking about a platform that's making money off of advertising. You'd think at some point they should start talking money before you have to try the case. But if you have to try it, you do try it. Where did you bring where'd you bring suit, by the way?
So we brought suit in a number of federal jurisdictions around the country. Those cases are now consolidated in a multi-district litigation in the Northern District of California in front of one federal judge. We've also brought cases in California state court, and those cases are now consolidated in front of a Superior Court judge in Los Angeles County.
When you're talking about proving the elements of the case, and we were discussing that earlier, and actually proving causation, or at least showing that, you know, the person watched the video and because of that the injury occurred, how do you do that? How are you able to show that it was a TikTok video and not another video that came from someplace else, or not just a friend who said try this? How do you do that?
Well, every case is different, and you know, we appropriately have the burden of proof, and we have to prove to a jury that it's more probable than not that the social media platform, in its dangerous design, was a substantial factor in causing the result. And you know, some cases are going to be more clear than others. We have a case where a 16-year-old boy was fed a series of videos from TikTok encouraging him to take his life and jump in front of a train, and he did step in front of a train and passed away. You know, those cases I think are going to be stronger than other cases where it's not. And you know, the court system is fair. You know, we don't expect to, you know, get where we need to go based on sympathy. We're going to have to prove each case one brick at a time, and that's what we do as lawyers.
But you're not really bringing a class action with respect to all these videos. Each case is taken individually. Am I correct? In other words,
that's absolutely correct. Yes.
This isn't a class action against TikTok for algorithm abuse. This is you take them one at a time, correct?
You take them one at a time and you work them up and you try them. And look, I mean, we've all tried a lot of cases. You know, I have the scars to prove it. But you know, we know that if you're not willing to go to trial, these companies are never going to take responsibility.
Who's handling this case or these cases for TikTok? Do they have separate attorneys for each individual action that's being brought, or is it just one general in-house group of attorneys that basically?
The platforms have one or two nationally renowned defense firms that are working for them. And you know, they're the largest firms in the United States. They're the most. Their lawyers charge the most per hour money, most per hour rate at any lawyers in the country, and they're very, very good lawyers.
So, what would you say to somebody now? You have a mom who's watching her dad, and you think their child is being influenced in a way that is, you know, really dangerous, and they see dangerous videos on their child's screens. What would you say to them right now? What advice would you give parents now who may have a child who seems to be, for instance, like my wife, who's very nervous about our 12-year-old because we don't know what he's sometimes watching on TikTok? What do you say to a parent who's watching?
First thing I say is lead by example. If you're on their phone all the time, you're not setting a good example for your kid. Make sure that just your kid has interactions with you and as a family, that they engage in sports and outdoor activities and other things unrelated to social media. I think that's kind of over and above what you need to do. The second thing is, and there's something called the Bergen Social Media Addiction Scale. And it's a test that you can take of 6-part questions with different answers to each of the 6 questions. And it will give you a number of scale as to whether your child has a social media addiction. And that's available on our website, socialmediavictims.com. The third thing is you have to be able to talk to your kid and have them be comfortable telling you about the material. And that's not always easy because, you know, teenagers aren't necessarily forthcoming with their parents about information. I think you need to be open with them, and you need to really let your kids know that they're being manipulated.
All right, Matthew Bergman, we're gonna have to leave it there. Thanks very much. Good stuff. Really important stuff. Maybe you can come back in the next couple of months and tell us how the lawsuit's going.
I'm happy to help, and thank you for taking on this tough issue. You be
It's
well.
absolutely our pleasure. All right, stay with us. Today's verdict has so much more right after this. Okay, welcome back to today's verdict. I'm your host and trial attorney, David Lesh. We have with us a returning guest, Albert Fox Khan, the executive director of the Surveillance Technology Oversight Project. Albert, thanks for being here today.
Thank you so much for having me back.
This is an interesting topic. It has to do with video of surveillance and different recognition software that is preventing certain people, mostly attorneys, from entering Madison Square Garden. Am I correct?
Yes, the owners of Madison Square Garden took a novel approach to getting sued. Instead of just fighting in court, they decided to fight the attorneys who are bringing these cases, banning them from going to Madison Square Gardens, banning them from going to Radio City Music Hall, and also just taking their images from their law firm's websites without consent.
Now, by the way, how does it work when you go into Madison Square Garden now with a ticket? Do they screen your face? How do they even know it's you walking in there?
So this is one of the things that would give me heartburn if I was Madison Square Garden's attorney. They are going onto these law firm websites, taking the images of everyone who works there, evidently, not just the attorneys on the case. And then they have cameras at the entrances, and they're doing real-time facial recognition, scanning against a database they've compiled of attorneys at these firms.
So they're able to see who's coming in through these various cameras. It's not like you're looking at a camera. The camera is just searching the crowd, and it's able to say if somebody's part of the class of attorneys that should not be allowed in.
Well, it can claim to do that. The problem is the software is error prone. It's been shown to be racially biased. It's much more error prone for Black women than for white men, sometimes more than 100 times as error prone. So again, it gets to the question of, even if it were legal to do this, it's not clear that it is. What happens every time you get it wrong? What happens when you try to kick people out of a game, even though they have nothing to do with these lawsuits?
Let's talk about, first of all, Albert, whether it is legal. Are attorneys considered to be a protected class when it comes to these private institutions? I can understand if you're discriminating based on ethnicity or on sex, religion, but this is just the class of attorneys, let's say. Do they have a right to be able to enter any private establishment that they want to?
So generally, a profession is not a protected class under federal law. It can be a bit more ambiguous under New York City human rights laws, which are much broader, but generally that's not a protected category. But there are a number of other legal avenues to challenge this. One is that these places serve liquor; they get a lot of money from their beer revenue in particular. And as a licensed place, you actually have to have a license from the state. And one of the requirements is that you serve all comers. They're not allowed to arbitrarily exclude people from a place that is a licensed liquor establishment. And then there are also questions about, well, what happens when you're excluding people using discriminatory software? Is that enough of a potential form of bias in who you're kicking out to bring a challenge under New York City human rights law? As far as I know, no one's ever made that sort of allegation, and it would be issue of first impression.
It looks like a lot of these cases now are looking backwards to some type of precedent with respect to even like the early 1900s, with respect to movie critics who were banned from theaters, that type of thing, or writers from the New York Post who were banned, who wrote certain things. This has been around for a while. And it hasn't always gone the way of the person who's bringing the lawsuit. People have been banned from going into certain establishments if it's private, but you're saying the sticking point here is the fact that there's alcohol being served, so you need a license, and that would be a little different?
That could be one of the things that makes it much harder for them to exclude people. And as the New York Times profiled just a few days ago, someone has challenged this under a law designed to protect theater critics. One of the things that I'm doing at the Surveillance Technology Oversight Project is actually pushing for new laws that would outlaw all uses of biometric surveillance in the future in places of public accommodation. That's something that's been done in Portland, something that I think is long overdue in New York.
Now, you've been on before, and we've talked about police surveillance and cameras that are used as facial recognition to be able to spot those who may have, committed a crime in the past. And we debated that. But when it comes to this type of surveillance, is one of your objections, and I think you made it clear that it might be, is that the technology is just not sophisticated enough to be accurate.
Well, yeah, the technology is error prone, the technology is biased, and it's even more biased when you're using it the way they're using it at Madison Square Garden, where you're using it in real time, you're surveilling a crowd, you don't have one-to-one images, and so it's much more likely to just get it wrong.
Well, how is it biased? I can understand how it's not accurate, but being not accurate, does that mean it's biased? I don't understand.
Well, according to research from NIST, from MIT, from Joe Buolamwini, a leading researcher in the space, when you look at the performance of the algorithms that drive facial recognition, a lot of them are much more error prone for Black and Latinx and Asian faces compared to white faces. And this gets into how are you training the algorithm? How are you setting it up to work? And if you are mainly using white faces to train it how to tell two people apart, you end up with an algorithm that is much more sophisticated and much more accurate for, quite frankly, someone who looks like me than for someone who's younger, who's older, who's trans, who's Black, who's Latinx. And so that leads to a lot more people being wrongfully kicked out.
So how is your organization fighting this? And what means? What lawsuits? What avenues are you taking?
So we have a number of lawsuits on the governmental side challenging the NYPD's facial recognition. We represent Amnesty International in one. We've brought one on our own, trying to get the documents about how the NYPD is using the system in practice. We also have a 10-point legislative platform that we introduced in Albany last week, a blueprint for banning Big Brother, as we put it, that would outlaw a lot of uses of facial recognition. And we also have legislation pending at the city council that would outlaw these sorts of uses of facial recognition. And I should say, it's not clear to me at all whether any of this was allowed under federal law, because you still have copyright issues when someone is taking a third person's photograph and using it without their permission as part of this facial recognition system. That could be a potential claim. And there are also issues under something called publicity rights or personality rights. And so there's a whole a laundry list of potential lawsuits that are coming towards Madison Square Garden.
We don't have too much time left, but I wanted you to make a prediction. Where do you think we're going to be in the next 5 years with respect to video recognition and software and surveillance? Is it going to be, the cat's out of the bag and we're all going to be in big trouble? Everyone knows what we look like, and everyone from the dry cleaner to the diner has a database to be able to go to. What do you think what's going to happen next 5 years?
I think it's going to be a patchwork across the country where we have some states that have more and more privacy protections, where your face, your images, your biometric data is your own. And we have states where it's a free-for-all. It's the Wild West, and people can use this technology however they want. And my hope is that we make sure that New York is one of the states that's actually protecting the public's privacy rather than just allowing the rich and powerful to use our data however they want.
All right, Albert Kahn, Surveillance Technology Oversight Project. I want to thank you very much. Thanks for coming back. I know you've been here once before, and hopefully you'll come back a third time in the next couple of months and let us know how this shakes out.
Looking forward to it. Thanks again.
All right, stay with us. Today's Verdict has so much more right after this. All right, welcome back to Today's Verdict. I'm your host and trial attorney, David Lesh. We have with us today Jose Hernandez from the Consumer Directed Personal Assistance Association of New York State. Did I get that right?
Sir. It's a mouthful.
Wow. A lot.
Yeah.
It's a lot. But you're doing some good work, and we want to focus today on the fair pay for home care. Maybe you could tell the viewers a little bit about why you're here today.
So I have a personal stake in this. I am a person with a disability who receives 24-hour home care. And over the last 5 or 6 years, it has become increasingly difficult to find home care workers to replace the ones that have come and gone due to the low wages. This is a phenomenon that wasn't happening, say, 15 years ago, because at the time, New York State's minimum wage was $7 an hour, and home care workers were making $10 and over. So we can find home care workers easier. Now we're trying to compete with the fast food industry that are paying up or more than the minimum wage.
It's funny you say that because to qualify for home care, it takes a lot more than just qualifying for someone who's working in the restaurant industry. I mean, you really have to go through so there's some testing and you have to get some schooling in there. When did you first notice that you were not getting substitutions of home care? How long ago did this really start to happen?
So when New York State decided that the minimum wage was going to increase, it increased across the board. It didn't matter if you was in the food service industry or in the home care industry. Everyone was at $15 an hour. So once that started to happen, individuals realized I can make the same amount of money working for a different company, and there was a lot more competition in the industry. So companies like from the fast food industry and Amazon started realizing that they can bring in more employees if they pay a little bit more. So it may not seem a lot, but companies who are paying $16, $17 an hour are really attracting home care workers to work for their companies. So around about the time that the minimum wage all leveled out across the state.
I'm going to read you a statistic. It says between 2021 and 2040, the New York State is projected to grow by 3%. But the 65 plus population, that'll be me, will grow by 25%. You'll have nearly 1 million job openings in home care by 2028. Where are we going to find these people?
If nothing changes, if we don't get the wage increases to attract new home care workers, a lot of those individuals are not going to go without much needed care or end up in nursing homes.
So where, tell me how you propose we do it. What do we raise the minimum wage to? And then once we do, maybe the second question you can answer is how do we get the word out so people know? Let's start with what do we raise the money up to?
A couple of years ago, we came up with the concept of fair pay for home care. And it was basically putting back the standard of the way it was before, when the minimum wage was $7 an hour and home care workers were getting paid 10. It was roughly 150% of the minimum wage. So in 2021 or 2022, 150% of the minimum wage, which was $15 an hour, would have been $22.50. We got an increase. The Governor Hochul gave great down payment. It was $3, supposed to be spread over the next 2 years. $2 were implemented in October. Another $1 increase would be next October. But that alone isn't enough to attract new home care workers because, again, Amazon is paying $21 an hour with a $3,000 bonus. So we need more. So we want that 150%. We want to get to that number. That is the magic number that will hopefully bring in more home care workers and, most importantly, raise them out of poverty.
And it looks like you have, I mean, there's a lot of people who are behind you here. I mean, it looks like you have and from what I see, you have so many assembly members and a majority of it looks like the assembly. When is this going to happen? When do you think this could happen?
Well, we have already started to roll out the campaign. We have had events in Western New York, Capital Region, and I was at the New York City launch where Jamani Williams, Assemblymember Reyes, Assemblymember Septimo, Assemblymember Forrest, Assemblymember Rosenthal, and Assemblymember Epstein attended. And we just need to continue to, bring this to their attention, get more support in the Assembly and in the Senate, and hopefully the governor really realizes how critical this is to keep individuals with disabilities out of nursing homes and make sure that our older population is also taken care of.
But do you find that's what happens when there's somebody who's not available to provide the support that you may need or somebody else might need, that your only next option is to end up in a nursing home? I mean, because where else are you going to go if you don't have family members who can do it? And a lot of times they can't. Isn't that really what ends up happening? They all overcrowd our nursing homes.
I'm also going to give you a few other scenarios.
Sure.
I know individuals with disabilities who end up staying alone without care. These are individuals who use motorized wheelchairs and can't turn in bed, but they either sleep in their chairs because they're more mobile, or they lay on one side of their bodies and get pressure sores. And this is where, our health is being is compromised because of not having the proper care. And there's even individuals who have chosen to stay in nursing homes because they can't worry about where the next person is going to come to help take care of them. So it's a really critical issue. People are really being hurt by this.
Where do you see us in the next 2 to 5 years? Give me a crystal ball. Give me your prediction. Where do you think we're going in New York?
Without fair pay for without fair pay for home care, or
where do you think we're heading? Do you think it's just going to be the fair pay? Do you think there's going to be even more support that those with disabilities can get, and even in other ways? What are your thoughts?
I think I'm hoping that this current administration doesn't take a page from the previous administration, and it values individuals with disabilities and older New Yorkers more. There was such a disinvestment in home care from the previous administration, and we just want to live in the community and be valued like everyone else. Seniors want to age in place. We don't want to be placed into a nursing home where it's 18 residents for one worker. We get better care, we have better outcomes, we get access to better doctors, and hoping Governor Hochul realizes that, in her 5-year plan, or in her term, she realizes that, we are valued.
All right, Jose. Well, we want to thank you very much for coming on. Hopefully you can come back maybe in the next couple of months and let us know how the fair pay for home care is heading, if you could do that for us.
Absolutely. You let me know, and I live in the Bronx, so I can come down to Lehman. That's
what I love to hear. Bronxite like me. All right, stay with us. Today's verdict has so much more right after this. Well, that's all the time we have for today. I'd like to thank you, the viewers, for watching us. And if you have a topic or an issue that you'd like to see on a future edition of Today's Verdict, feel free to email me at davidlesh@bronxnet.org. Until the next time, know your issues, reach a verdict. See you in 2 weeks.